Good morning, everyone. Welcome to Jail Car. All right, we have 10 members, so Representative Grassi can sit in for Senator Chandley, who's not here. Oh, I'm sorry, excuse me. You're being blocked. You are here, okay. And Whitley, if we have a full team of senators except for Senator Lang, okay. So, all right, Representative Grassi can sit in for Senator Lang, who is not here. Representative Hacken Phillips and we have 5 House members. Where?
I'm leaving. What the heck, you don't need me.
7 House members. Okay, we have a surplus, so Representative Hacken Phillips, you're on deck. Okay. The minutes of the previous meeting, do we have a motion?
So, second.
Any discussion or corrections? I
Was that-
believe so, yes. There were several enthusiastic people, but she was one of them.
I wouldn't go that far, but
And any discussion or comments on the minutes? Those in favor?
Aye.
Opposed? All right, the consent agenda. Item K has been requested to come off by Representative Leon, so we'll do that. Do we have a motion on the rest of the consent agenda?
second.
Okay, Senator Ennis and Representative Schmidt. Any comments, questions, or concerns? All right, seeing none, the motion is to approve the consent agenda. Those in favor? Opposed? Okay, thank you. On the regular agenda, we would like to postpone item I, which is the Water Council. It's their request. So do we have a motion to do so?
No move.
Okay, Representative Schmidt and a senator. Seconded? Okay. Those in favor?
Aye.
Opposed? Okay, that one will be on the January agenda. All right. Department of Safety.
So this is proposal 2023-72, the watercraft safety rules. This was one that had been postponed previously due to a number of comments the department wanted to address on the final proposal. They did submit a conditional approval late Tuesday. I started to review it. There were still some substantive comments on it that the agency and I are still working on through discussions. But at this point in time, due to it being postponed and there still being some issues, I would recommend the committee make a preliminary objection at this point and allow the agency to address those issues in a preliminary objection response.
Okay.
I'll move that.
Is there a second?
Second.
Okay, Representative Lynn seconds. Good morning, Mr. Hillside. I take it you are in fact working on this?
Yes. Good morning, Attorney Dave Hills for the Department of Safety. I just wanted to thank the committee for the patience that it has had so far with this proposal. I know that in the last couple of cycles, we essentially asked for more time. We've had some challenges with the amount of comments, but also some unavoidable absences in a couple of the personnel that have been on this, and we do appreciate the extra time. As Rebecca said, if the committee were to give us a preliminary objection, we would be continuing to work on our response.
Okay. Any questions, comments, or concerns? Seeing none, those in favor of a preliminary objection based on staff comments?
Aye.
Opposed? Okay, thank you very much. All right. Board of Nursing.
Okay, these are licensing requirement rules, the nursing 300s. So this proposal was postponed from the last meeting to allow the agency to address the legislative intent comments and the unclear comments. And a revised amended conditional approval request has been filed, and you should have that in front of you. The first comment is on page 2 of the PDF. At the last meeting, we discussed at length the language in the rule, specifically in the statute. The statute allows for 3 types of licensure, and that's by endorsement, alternate experience, and forget the other one, but
Examination.
anyway, so right now the rule still says alternate education when it should read alternate experience. And I spoke with Tina a couple of days ago, and this is a mistake. And so she plans on asking, as part of the conditional approval request today, to change that there in that section, and then also in section E below. And so besides that, you'll also see a comment down towards the lower left of the page that points out a need for legislation to address the fact that there's still fee authority in this particular board statute. And that's just an FYI. And again, on the fee authority, there has been an updated informational note that we've been placing on the board's rules. You'll see that on the last page. And the reason for that update is we sat down with the OPLC and we took a look at HB 518, and that is currently in process, and that should deal with the issue around the fees. So if it should pass, we shouldn't be needing to make that comment any longer. And the agency will be doing some rulemaking and is looking at some of their rules as well. The only other issue with the proposal is that there are some legislative intent comments because the remaining sections of the rule have been expired since March. And I think that the committee kind of talked about it a little bit last time, but there are some fees associated with it. So you may, thought I would mention it. But anyway, those are the issues with this proposal.
Good morning, Ms. Kelly.
Good morning, Tina Kelly, Office of Professional Licensure and Certification. With regards to, with everything that Rebecca said, we're going to make the change from education to experience. And with regards to the expired rules, it's either that they're smaller part of a larger section or they're in statute. And so they've only been enforced with regards to what's in statute. Fees are all covered in OPLC, and I believe that was before March that OPLC's fees went into effect.
No, their fee rule actually went into effect in July, so there is a gap from March to July.
Fees for nursing, they were expired from March to July. Were they charged those fees? I'm not sure.
Good morning, Executive Director Lindsay Courtney, Office of Professional Licensure and Certification. I apologize, I wasn't prepared to address this issue today. The Board of Nursing had a series of emergency rules as well, so I'd have to go back and review to see whether those rules included fees. But I do agree with you that our fees went into effect in May.
May.
No, that proposal was 2023-52. I think that was in the PLC 1002s. I think they went into effect in July or August. I think it was July. Rebecca Ricard is saying she believes it's July too, but
You
The-
could be right,
In
Kim.
any event, Director Courtney, I think the simplest thing would be if you went through your emergency rules and the statute and identified any fees that were inappropriately charged.
Absolutely. Will do, Representative.
Thank you. Any other issues with these rules? Questions? All right. In that
and
case-
like I said in the outset, the board will need an oral change to the rules to change that the alternate education to read alternate experience.
Okay, do we have such a motion?
I'll make that motion.
Okay, is there a second?
I'll second.
Okay, Representative Lynn, Representative Grota. Any discussion, comments, questions? Those in favor?
Aye.
Opposed? All right. Thank you very much.
All right, the next, excuse me, the next proposal is 2023-141, definitions of financial assistance and medical assistance. This particular proposal did have a CA filed with our office after the deadline. We have had so our comments going back to the agencies a little late this time around due to some illnesses and absences in our own office. So we would be in favor of the committee granting them a waiver due to the late CA. And in that conditional approval, they did address two of the issues. The first is on page 14 of the conditional approval. They did change the citation from the federal regulation definition of dependent child and cited the statute. However, I still had a little bit of comment on that due to them saying it was a definition. And even though the statutory title of that section says definitions, when you read it, it's not actually a definition. It's more of a description of what a needy child is in order to be eligible for the financial aid. So I just, in my comment, proposed some language to just change that to say dependent child means as described, excuse me, a needy child means, excuse me, I'm not feeling great, I apologize. A dependent child means a needy child as described in RSA 167.6 Section 5, as opposed to what's written, which could be addressed in an oral amendment to their conditional approval if they agree. And then the only other comment is on page 20 of the conditional approval text, where the agency is not using the statutory definition of specified relative. However, in talking with the agency, this was an intentional choice, as it seems that this state statute is being amended to include court-appointed guardians. That's a change I believe will take effect in early this upcoming year. And due to these being Medicaid rules, that is not something that the federal regulations allow. Court-appointed guardians is more for the purpose of TANF assistance as opposed to Medicaid. So they are intentionally not adopting the state statutory definition for that reason. And those were the only two comments I had on the conditional approval.
Good morning, Nicole Valenzola, Rules Coordinator for the Rules Unit for Department of Health and Human Services.
Good morning, David Shorney, Deputy Medicaid Director.
With respect to the definition for dependent child, Attorney Ricard, could we just keep it, I agree with saying as, I can't see you, but as described in, can we just keep it as a dependent child and not add the needy?
Just to make sure I'm clear, so it's dependent child means,
A child and then as described in?
I would say that would also be fine.
So we will make that change. And then with regard to specified relative, I think it's, if any members of the committee have additional questions after what Attorney Ricard.
I have a question. What does this mean, that a guardian of a dependent child who is on Medicaid is not themselves eligible for Medicaid? Or is there something else going on that I don't quite understand?
Hi, good morning. My name is Dawn Tierney, the Medicaid Policy Administrator for the Department of Health and Human Services, and that's not what it means.
Thank you. What does it mean?
It just means that, I don't want to oversimplify or very complicated, but it would mean that the non-relative legal guardian, if that status permits them to claim them on their taxes, that the income of the guardian would then count towards the child's eligibility, where if we don't include that definition, the their income will not count towards the child's eligibility. So if the potential is that the child would maybe lose Medicaid eligibility versus keeping it, or on the other hand, the guardian may be in a parent caretaker relative eligibility category, which we only get a 50-50 match for, whereas now they could be in their own household and be eligible potentially under Granted Advantage, and we would get the higher federal match at the 90-10 rate. So we didn't really have a lot of time also to analyze this by the time the statute took effect to determine whether or not it would be more beneficial for the child or the court-appointed guardian.
Representative Schmidt?
How soon are you going to know the answer to that?
Probably not until after this takes effect, because we don't know really how many people we're talking about.
That's the other question I had.
Yeah, I don't know.
Okay, so you're trying to maintain the current status for court-appointed guardians and not include them in the general definition of
Yes,
responsible adult for,
Yes.
for a child on Medicaid
yes,
until you figure out whether they ought to be there or not.
yes. And what the cost could potentially be to the department and to the state.
Okay, and as I recall, when we changed it to allow the guardians to get TANF, we didn't discuss the issue of whether they were already eligible for Medicaid or would be eligible for Medicaid, so there's no clear legislative intent, at least as far as I remember. Does anybody have any more information? Okay, none of us have any better information, so if we have a motion, I'd like to have you consider this and report back when you have a chance, because it's obviously something that was left hanging when we changed the guardian rules. Representative Moore, oh, excuse me, Director Morrow, excuse me.
Because we have a late filed conditional approval request and there's an oral adjustment, the committee would have to vote to accept that separate from voting on the proposal.
Okay. Do we have such a motion?
So moved. Second.
Okay. And Representative Brassey, you're back on deck. And discussion, comments? Those in favor?
Aye.
Opposed? Okay, so now we can consider the rule. Is there a motion on it?
Move to approve as edited.
Second.
That is including the verbal correction and the action to report back on guardians. Comments or questions? Those in favor?
Aye.
Opposed? All right, thank you very much, and I'd love to find out what happens with those. All right.
All right, 2023-193 on hospice services. The rules have been expired since 2018 and 2022.
All right.
Good morning, Nicole Valenzola, again, for the record, Rules Coordinator for Department of Health and Human Services. Attorney Muniz, before are we able to, we made the other editorial corrections for you as well with the conditional approval
Yes,
request? Was
that's correct.
that's all set?
That's what we're talking about, the conditional approval.
Yes, okay.
Yeah.
I wasn't sure if we needed to go over those details first or anything. Okay. Expired rules, yes. It sounds like in speaking to the program area, there was some staff changeover around the time of when this rule is expiring. It was missed. As soon as we caught it, we began regular rulemaking at that time.
How could you deal with hospice services, which I can imagine are pretty substantial, without having a rule in place?
So under the New Hampshire statute, it directed the department to file a state plan amendment to cover hospice services up to the extent that Medicare covers them. So we've been following the Medicare regulations with respect to hospice services. And the regulations really apply to the fee-for-service population, which is only about 1.5% of the Medicaid population. Most of the population is in managed care. And so the hospice services are delivered through the managed care organizations, which the state contracts with in accordance with their program manuals.
Representative Broda.
So for those people who required the services that were not on Medicare, how was that handled?
So the Medicaid rules follow the Medicare rules. So when operating the program, we operated it consistent with the Medicare conditions for coverage and the Medicare federal regulations. That's how they were. The individual didn't need to be Medicare eligible as long as they had Medicaid and they were in fee-for-service. We operated the program in accordance with the Medicare regulations, which is what we were directed to do underneath the New Hampshire statute.
So you were using the existing Medicare rules for people who are not eligible for Medicare?
But they're eligible for Medicaid, which is the coverage benefit.
Yes, thank you. Please.
So for those people, let's pretend like me, who are not on Medicaid and not Medicare, how are those services administered?
They're administered through the Medicare program, which is run through the federal government.
If you're not on Medicare and you're not on Medicaid, your own insurance presumably would deal with hospice.
Okay,
Yep,
that's what I'm looking for.
Covered
Thank
through
you.
your commercial plan.
Okay.
Yes,
I'm
so say
thank
the
you.
marketplace.
Okay, thank you. That's helpful.
All right.
Any
Senator?
enforcement action during the expiration of these rules that were penalized hospice care services? Was anybody penalized at all? Absent any if we had these rules that violated the state rules, was there any enforcement action at all?
I don't know. I'd have to take it back. Full disclosure, I started in August, so I don't have the full benefit of history since 2018. I don't know if Don knows, but I can take it back and follow up.
You might, I don't know who would be responsible for doing this, but it sounds to me we have a real mess here with multiple sets of rules. And I find that it's going to be very difficult for people to know which rule applies. And how can we straighten that out? Director Morrell, do you have an idea?
Absent a legislative change, I do not know.
Okay, so it's in our court then.
I think so.
Thank you.
Move to approve the conditional request.
Second.
Any discussion, questions, comments? Those in favor?
Aye.
Opposed? Okay, thank you very much. Good luck. All right.
So the next one is 196, determination of the assistance payment, and that one has been expired since 2022.
That's the only issue with it?
Good morning. Again, Nicole Valenzola, Administrative Rules Unit, Department of Health and Human Services. With respect to this rule, to be completely honest, this was an example of when a program or an agency used to be allowed to open up one single paragraph and make an edit. And so therefore the section had sort of multiple different expiration dates. And so this is an example of how part of the section was missed due to part of it not being expired and part of it being expired. So we are happy that that's no longer an option, but that's the truth of how this one was missed. And then within that section, honestly, it's actually, this rule is the bulk of it is just about how determining assistance payments and the timeline. So the bulk of the rule is discussing sort of at what time a payment is made, et cetera. And it's only addressing, again, this specific population of folks receiving assistance who say they may be living with a grandparent or something and then they don't have a shelter cost. And so they have a 1/3 reduction of assistance. So the bulk of the rule is just talking about what days of the month you might be administering payment, et cetera.
Senator?
Just so I'm clear, so again, you had one paragraph out of an entire rule that expired, and this now brings the whole rule into, we have a single rule, not paragraphs that have outliers.
Opposite. We had one paragraph that wasn't expired with the other paragraphs expired, but that last paragraph had to be the one not expired.
Thank you.
So it
Move to conditionally approve.
Second.
Any comments, questions, discussion? Those in favor?
Aye.
Opposed? All right.
Thank you.
All right. Ambulances.
So this one is actually an interim rule. The agency filed this interim rule because the effective rule expired on December 1st of this year. They did file this rule prior to that expiration, but unlike in regular rulemaking, the filing of an interim rule will not stay that expiration date. But that's why Part E of RSA 541A19(1) allows agencies to file interim rules to limit the amount of time a rule is expired before regular rulemaking can occur. The agency had originally filed the rule as it was effective. Because this rule had not been in rulemaking since 2013, it was a little bit outside of our current manual standards. So they did file a conditional approval to address the lack of certification that was needed to be in the rule text and also to update one of the form names. So the only comment I had is that the current rule is now technically expired and has been since the 1st of this month.
Good morning.
Good morning, Allison Radmay, the administrator for the Administrative Rules Unit at the Department of Health and Human Services.
Good morning, Dawn Tierney, Administrative Policy for the for the Department of Health and Human Services.
With respect to the expiration of the rule, immediately upon realizing this was to expire on December 1st, we knew we couldn't file regular rulemaking and get the notice to OLS on time. So we did immediately put this into an interim rule, and we are prepared to move forward after the holiday, probably the first week in January, to start this going into regular rulemaking.
Okay.
Move to conditionally approve.
I'd like to ask if there were any enforcement issues.
None.
Okay, good. Is there a policy in HHS to examine your rules for expired rules? Because I was very shocked that you had so many expired rules showing up this month.
We're trying our best. There's 2 of us in the unit, and there's 3,000 rules about in the department. So as we have a new program that we're kind of trying to work with, we don't love it too much, but we're also on our own as we are certifying rules. We're actually updating our own spreadsheets so we can kind of try to let programs know. But again, there's 2 of us and about 3,000 rules. So
okay, well that's an
we're trying our best. That's why you were seeing so many kind of come forward, because we're trying to identify them.
Okay, thank you.
Yep.
Any other questions or comments?
Just a comment on our side of the things. We are trying to incorporate basically a warning for when the rules will be expiring. That will be a new thing coming with our new system as it comes up, just maybe a few months.
Okay, well, that will help because private spreadsheets are notorious for missing things. All right, we have a motion? Yes, okay. Any further comments, questions? Seeing none, those in favor?
Aye.
Opposed? All right, thank you very much and good luck. All right.
So next item is 2023-152, the establishment and operation of area agencies. This one also had a conditional approval request filed that addressed almost all of the comments that was on the final proposal. The only remaining comment, and it seems to be maybe just an unintentional error, on page 6 of the conditional approval request text, they had changed one term in which I had commented on. They were using the term developmental disability service system, which was not a defined term. The statute had defined service delivery system. And in that particular section, they changed the first mention of it, but the second mention of it, they left it as the developmental disability service system, which could be addressed if the agency made an oral amendment to their conditional approval request, and then that would address all of the issues in this proposal.
Okay,
Good morning. Again, for the record, Allison Radmay, the administrator of the Administrative Rules Unit for the Department of Health and Human Services.
Good morning, Attorney Melissa Nemeth with the Department of Health and Human Services.
This was an oversight on our part when we were making that initial wording change to subparagraph 8. So we do agree with the change in 8B to change developmental disability service system to service delivery system to mirror what the language above is.
okay. That will,
Move to approve the oral change to the conditional approval?
Second.
any further questions, comments, concerns? Those in favor?
Aye.
Opposed? All right, thank you very much.
Move to approve as edited?
Um,
We have to adopt the oral first if we did it like last time.
oh, the,
Yeah. And so now we're back on the rule itself as edited. Move
Okay.
to approve.
Second.
any comments? Those in favor?
Aye.
Opposed? All right, thank you very much. That's that one. Board of Mental Health Practice.
Chairwoman McGuire, did you want to take up the item that was moved from consent? It's also an HHS proposal.
Yes, well, we've got them up there. That would help. That's item K, which is number 243, the impaired driver programs. Representative Leon took this off consent. So, if you,
Sure. This was on the impaired driver programs, and I think we did some back and forth with the agency, and they filed a conditional approval request, and I think I only had a couple of editorial comments left on it, which they could handle, in a response. But I wasn't sure if there was anything else that that we needed to address. I don't think I had any informational notes on this one either.
okay, Representative Leon, if you would express your concern.
Thank you. As I was reading through, I know that these programs have been operating through video conferencing, so that's a virtual face-to-face, but not an in-person face-to-face. I just wanted to make sure that the rules, assuming that that's something that was an intention for the department to continue, that the rules specify that face-to-face includes a virtual face-to-face and not just in-person face-to-face.
Good morning again, for the record, Allison Radmay, administrator of the Administrative Rules Unit for the Department of Health and Human Services.
And I'm Jenny O'Higgins, a senior policy analyst for behavioral health with DHHS.
I have spoken with the program prior to coming up here, and we have agreed to add a new definition of face-to-face. So this would be a new paragraph P, and we would renumber the remaining definitions. And what we have is means in person or via an online platform in real time when all participants can see each other clearly.
That would work for me. Thank you.
Thank
Okay.
you.
So we would need to have a conditional approval motion.
So moved.
Second?
All right, any further discussion, comments, concerns? Okay. All in favor?
Aye.
Opposed? All right,
And you'll submit that in writing to the OLS? Thank you.
okay, that's good. All right.
And I believe there was public testimony too. Sorry.
Oh, okay, you're right, public testimony before we leave. Let's make sure we haven't done something you would object to. Marion Kelly? I'm sorry about that, we're, please turn your mic on.
Push the button.
Push. There you go.
How's that?
Beautiful.
Marion Kelly, Assistant Director, Amethyst Foundation. I would specifically, I've had to write this down and I'll keep it brief. I'd like to specifically address the fee increases pursuant to HEA 50501. When RSA 265A was signed into law effective January 1st, 2013, the statute significantly revised delivery of services. An unintentional consequence of the law has been a reduction in IDCMP revenues that has led directly to the closures of several IDCM programs throughout the state. I counted 6 this morning, just off the top of my head. Amethyst Foundation has been incorporated for 41 years, and as such, we are well acquainted with the business acumen needed to run a successful nonprofit. Since 2013, Amethyst has managed to stay solvent by the following measures. We've tightened up expenditure across the board. We are not doing capital improvements. We're temporarily closing offices, and we're not filling positions as they become vacant. After several years of warning by our auditors, it has become apparent Amethyst can no longer continue to serve the population in need of DWI programs without the proposed fee increases. You may or may not be aware that's the only source of revenue for the IDCMPs. It's fee per service. Many of the, as some of you may know, the IDCMPs met monthly over the course of 6 months to assess the rule changes, and specifically in this case to look at fee increases. We were very, very careful. We wanted to represent the cost of living adjustments, and we were really careful balancing the needs of the clients with the ability of the IDCMPs to continue to offer IDCM DWI services. So I'm just urging you to accept and confirm the proposed fee increases. You do not want to see DWI programs not be able to operate because of the reduction in fees that the RSA unfortunately allowed.
All right, thank you very much.
Any questions?
Well, I have a question. I'm looking at the schedule of fees. It comments that the emergency rule expired in April. How on earth have we been running the programs for the last 8 months?
Are you asking me?
I'm asking anyone who knows. Are you? Do you know?
Oh, no, we've been very aware that the rules expired and very concerned about it. But Nicole would know. Or Alice, are you set with me?
Thank you.
I'm sorry, can I just ask one question before you run away? So you're talking about the fees that are defined in this fee schedule, you feel need to be increased in order to allow the program to remain viable?
The rules show the increases that we felt were fair to
And
clients
so these are
and the programs.
the rules that we already adopted, you're okay with?
Yes.
Thank you.
Okay, thank you.
Okay, thank you.
I have a question. So the document you were reading from, we have that document you were reading from, we have that in our,
It was not submitted to the office prior to this meeting. If you wanted to forward it to our office, we could disseminate it to
The
the,
document of.
that you were just reading
Oh,
from your
sure.
statement.
Okay, I will.
thank you.
It will be part of the transcript too.
Thank you.
Good morning, Allison Radmay, Administrator for the Administrative Rules Unit of the Department of Health and Human Services. That's a mouthful when you're saying it like 5 times. So I did want to clarify HEA 50501, where which houses the schedule of fees, that was not expired. That was not expired. The emergency rule that we put forward was only dealing with the credit card transaction fees that are provided or charged by banks, allowing the programs, I believe, to collect those fees from their clients, so they wouldn't be losing money. We originally were trying real hard to get this rule through, but we wanted to prevent expiration, so we did a lot of stakeholder work on the back end, which kind of required us to push it off coming to GELCAR. But it was very minor, a very minor rule change that was expired. It was not the entire fee schedule.
Okay,
Yeah.
thank you.
And
That's
I
a
want to
re-
clarify
that's a
that.
relief.
And this
Yeah.
rule that specifically expired again is if they had a $100 fee and it was a $5 credit card charge, they could charge $105 rather than a flat $100. They would be able to recover the banking costs, basically.
Exactly. We didn't want them to be out because essentially they were losing revenue because they were paying that cost of those fees. Yeah.
And the existing rules, other than that one piece,
Were not expired.
were not expired.
Were not expired.
And even if they were, they would have been continued because you were in rulemaking at the time,
Correct.
correct? Okay.
Correct.
Yeah,
Thank you,
that's
I'm
correct.
relieved.
I'm looking at the emergency rule and that's correct. It was just for that one piece, so it had a paragraph that just had the transaction fee for every payment made, the transaction fee. So that was all that was put into place with the emergency rule. And so when the emergency rule expired, the rule just went back into effect as it was.
All right, thank you very much. I'm relieved.
Thank you.
All right. Any other issues? Okay, thank you very much. All right. The Board of Mental Health Practice.
Yeah, so there are just 3 issues that are keeping this item from being on consent. There has been a conditional approval request filed, but first is that there are a couple of places in the rule that the board, that the rule says board rather than OPLC. And so Tina planned on orally requesting for that change, and that's in a couple of places on pages 3 and 7 of the conditional approval packet. The second reason is there was some difference between the fees on the board's website and what's in the PLC rule, but Tina and I walked through those, each one of those fees, and that's due to the program health facility, that program fee rather. And so there's no issue there. Lastly, there's been some testimony submitted from the Community Behavioral Health Association, and that is linked on the website, as well as an email exchange from Tina talking about that testimony. So the testimony says that it's not possible to complete the required supervisory experience within 4 years, and that amount of time that has to be done is 100 hours. The board says that the requirement has to be met within 4, not 2 years. And the rules don't cap the number of hours per week that a supervisory experience, that number, that amount that they can do for each week. I took a look at the rule and I think that's correct. It doesn't talk about a maximum amount. It talks about a minimum, which is roughly about an hour a week. And so I don't think that the rule's been read correctly around that piece of it. So, that's roughly, like I said, about 1 hour a week. So
Okay.
about 54 hours a year. So they could meet
52
it.
hours a year.
Right.
Less
Sorry,
vacations,
52
of
hours
course.
a year. Right.
So is that 1 hour a week a minimum or a maximum?
That is a minimum. So they could do more. And it's doable within 2 years, but they do have 4 years. They could renew it and have up to 4 years. There was a comment that there wasn't a limit on it before. It's only so that somebody doesn't go forever. So 4 years is completely doable. And the other part of this is that the certification is not required, from what I understand, and it is simply for reimbursement purposes.
Let's see. Is everyone happy with the supervisory being No more than 4 years. Any issues with that? Okay, so is that what the rule states?
Yeah, that's the way I read the rule.
Okay, so we'll try and make it more obvious if there's confusion. But you're right, 4 years seems like more than enough time to get to suffer through that. Okay, so moving on to the next issue. What certification?
Thank you, Madam Chair, members of the committee. Lindsay Courtney, Executive Director, OPLC. So this certification came about, I believe, in the 2019 legislative session. Historically, the way mental health providers have obtained their license is they graduate, they have to get a period of supervised experience. They had to submit an agreement to the board. It was a candidate agreement that was approved by the board, but it wasn't a license. And they were able to essentially practice under supervision. And then at some point, they apply for a license. But during that period of time, they're not able to be eligible for reimbursement because they're not actually licensed. So during, I believe it was 2019 or 2020, the statute was changed to allow for licensure, but the portion of the statute regarding candidates has not yet been repealed. The way I interpret that is that it's essentially an optional pathway for those who want a license while they obtain their supervision.
And the license allows them to do what?
Be reimbursed for services. It's a reimbursement issue as opposed to authorization to perform the services issue.
So again, if I may.
Please.
So again, this is an insurance issue really, right? So the
Correct.
ability for, without a license, they cannot get reimbursed from an
Correct.
insurance carrier, but with a license, they can get reimbursed from an insurance carrier for services provided.
Right, but the statute did eliminate the option to do it without the license.
Okay, so they are working under supervision, but this allows them to be paid for the work they're doing under supervision.
Correct.
Okay. That doesn't appear to be the understanding of the people that wrote us that letter and submitted the testimony. Okay. So we'll try and, obviously, it's a communication
Madam
issue.
Chair,
Yes, Representative Groda.
can you explain then the reason for this misunderstanding? Because this was not addressed by the board during the hearings.
So correct. This issue didn't come up before the board. The issue that came up before the board was the 2 years and the minimum 100. I guess the point that I was trying to make is that if the concern is that you can't complete within 4 years, 100 hours, it doesn't mean that you would never qualify to get your license as a clinical mental health counselor. It just means that you would do it and not be eligible for reimbursement because the statutory authority for the candidate agreement process is still in statute. I will say there's a proposed piece of legislation that would repeal that, but for right now, there remains 2 pathways.
So we're really so far, excuse me.
Follow up, please.
Follow up. We're really only addressing right now the first letter because we have two areas of concern from the
Right, and when I read the letter, it's implied that the certification was not for counseling, it was for other duties. So it sounds like there's a major miscommunication.
Follow up,
Follow up.
please. But this letter was presented to the board before the hearing. So they knew about it and they didn't address it then, or they didn't. So I just don't know why that would happen.
I do think, and I'm not going to speak for the board because I represent an entirely different entity, but I do believe that they did address it. It's set forth in the final proposal. The issue regarding whether 100 hours is, or I'm sorry, 1 hour per week is a maximum versus a minimum, as well as the renewal time frame, that was addressed. The board just believed that 4 hours was a sufficient period of time in order to complete your supervision.
Okay, but what about their concern about the duties allowable with that certification? Is that a real issue or just being confused?
I'm not sure about that. I didn't have this. I will say that the board addressed everything that was in the letter, and they did go through it step by step. On that particular issue, I don't know exactly what their reasoning was. So I can't address that at this time.
All right.
Yeah, I can't speak to the scope of practice issue. We did send the letter to the board yesterday and requested that somebody be able to attend. They weren't able to attend. And I can't speak to the scope of practice issue. That's entirely under the purview of the board.
Okay. But your understanding is that this certificate is for someone who is working under supervision, and the supervision agreement has been approved by the board.
Correct.
Okay, so, thank you. Any other comments, questions, concerns?
Move to approve.
Okay, comments? Those in favor?
Aye.
Oh,
Excuse me. There's so many, to me, it's still not clear. I'm just wondering if we can postpone this for the next meeting. Do we have time to do that?
We do. Our deadline is after the next meeting. Director Morrow?
But we do have a motion to approve.
Motion and a
on
vote
the
already.
table.
Pardon, sorry.
What's that?
If there's consensus to push off, I can move to reconsider.
I think that would be appropriate, yes.
Second.
No.
Okay. We have a motion to reconsider our vote. Those in favor?
Aye.
Opposed?
Aye.
Okay. And then there is a motion to postpone the final approval until our January meeting with the hope that the board will be able to address some of these issues by then. With that, is that the intent?
No.
Okay. So we have a motion to postpone? Okay, those in favor?
Aye.
Opposed? All right, we will see you in January with a report from the board, and hopefully all our other issues have been resolved. Okay. Anything else, Director Morrow?
We have two items under other business. The first is an emergency rule from OPLC. It was filed a week ago. This summer, I think it was in July, OPLC adopted PLC 1002, a lengthy proposal, I believe, due to a number of statutory changes. As part of it, the licensure period or the period for certificate of authority for architects and professional engineers changed from 12 months to 24 months. At the same time, the fee doubled, which appeared logical, and no comment was made either from us or the public. It turns out in retrospect that that was not the intent of OPLC, that they intended to keep the fee the same. And they are concerned about there will be costs to the engineers and the architects. I mean, there does seem to be an emergency. It's in essence created by the agency through oversight, apparently. And there is a discussion of the number of people, close to 1,900 between the two boards. And they're talking about close to $350,000. But I'm not sure of that sum, because that would, I assume, be for the 24-month period. I mean, if they start rulemaking immediately, within 3 or 4 months, they could have the regular rule finished. And so I don't know what the actual amount would be. I don't know when whether these people, licensees, are all licensed at the same time, whether it's staggered by birth month or what, but perhaps the agency can answer.
Thank you. Lindsay Courtney, OPLC Executive Director. So, Attorney Morrill is absolutely correct. In this past summer, we had attempted to take all of the board's existing fees and put them into one proposal, which was approved in PLC 1002s. There were a couple of changes in statute to the statutory term. Some went from 3 years to 2 years, and some went from 1 year to 2 years. So the intent was to take the existing fee and double it to account for the 2-year time frame. What we actually did with respect to the COAs was quadruple the fee. And so instead of it being, so originally one of the fees was $77.50 for 1 year. Instead of it being $155, we set the fee at $310. I think that was just due to drafting errors and multiple revisions and not understanding if we had already made the calculation or not. We did not receive any comments from the boards. We did not receive any comments from the public until about 2 weeks ago. We received a comment, and then we reviewed the matter and realized that that was not the intent. And I think it's the right thing to do. So we filed the emergency rules, and we're working on refunding the people who have already paid for renewals.
So the engineering and architecture licenses go out over the course of the year?
Yes, correct.
All right. Any other discussion on this issue, this rule? All right. Well, thank you for catching up.
And thank you for doing the right thing.
Thank you.
All right. All right.
The remaining item is the schedule of Delcar meetings for next year. I think you each have a copy. The regular meetings are as normal, which would be the third Friday of the month during the first 6 months of the year because of session. In the second 6 months, they would be on Thursdays to avoid having you come in during the summer on a Friday. The continued meetings are always subject to change. Legislative schedule may change. We've tried to avoid holidays, but certainly those can be changed on an ongoing basis.
Okay.
And we would need a motion and
Move to approve the dates.
Okay.
Okay. Moved by Senator Lang, second by Representative Schmidt. Any discussion on these? We did check, and none of them are on Easter, which is the most important floating holiday in the spring. Okay. Any discussion? Those in favor?
Aye.
Opposed? Okay. So we will be back on January 19th.
Yes, assuming that we're not having a continued meeting.
I don't see any need for one. Does anybody? Okay, we will cancel the continued meeting and come back on the 19th. Anything else? All right, in that case, we are adjourned. Thank you all.
Happy holidays to you all.
Yeah, happy holidays.
Yeah.